Well, good morning, everybody. How are y'all doing? I This looks rocking good, y'all. Hi, my mods. Hi, mod family. Oh my gosh, I am so blessed to have you. You guys, I am so much more peaceful about go doing this with the mod family. Mod family rocks. That's what I'm gonna say. Mod family rocks. Yeah. I'm kidding. Um, me. I want to see something because there was a setting on my camera and I didn't know it. Yeah. My mods are having fun over here in the chat. There was a setting on my camera that I didn't know it that was blurring me. And now I hate it when you get a spot on your glasses. Oh, snap it. I want to try and do it without my glasses, but I have got yeah, I'm going to have to. Got a bad headache today, y'all. So we've got a lot to talk about. We have why am I not coming up on my own home? Go to my home, homie. Why are you not showing up? Um, Today I think I've got some great news and I got some not so good news. I got great news and not so good news. Are y'all ready for some of
Great
it?
news and not so good news.
Oh, wait a minute. Let me turn me down. Y'all ready for? There we go. Y'all. Hey mods. Hey mods. Hey mods. Hey mods. Does the image look better today? Good morning, my precious mod. I want to call y'all my moddies. And there's a reason why. I had a friend named Maudie. And he was the wife to my dear friend Evelyn and Maudie Smith. They're both deceased by years. And his name was Maudie. So I may call y'all my moddies. What do you think, Maud? I'm liking the image on this better. No, the filter is off. And it is definitely clear. I'm looking okay, y'all, my camera I had was called a soft filter. And so I turned it off. I can tell a huge difference in my camera. My son's telling me it's still on. No, it's off. And I'm looking, my eyes are sharp. My skin is that smooth, bro. My skin is that smooth. Okay, good news one. Oh, thank you, Kathy and Linda, for the Nespresso machine. I've had it for a little while, but y'all, migraine days, Nespresso is my best friend. Good news is I love y'all. The bad news, the Karen retrial will not start till Monday. But I've decided that I'm going to break protocol because this particular trial has more rabbit trails than anything I've ever dealt with. So we are going to be watching some video on the trial. Okay. I just think at this point with this particular case. By the way, what do you think about my beret, y'all? This is all hand beaded, Native American. I figured I'm going to move it up a little bit. But I think for us to be able to really appropriately follow along, I am going to have to get a lay of the land. Oh, I know. Aren't they great? I love them too. It can go kind of like it's flying, or I can put it straight. I kind of like it like it's flying, kind of like that. So we're gonna catch up with some of the videos and everything on it because I'm at a point right now that I think I think I need to do that. If y'all mods, are you okay with that? Oh, y'all, this headache. Give me about 15, 20 minutes. I took a headache pill and maybe a snap of food may help. Um, Anybody else suffer from migraines? Y'all, migraines are the worst. Migraines are the worst. I've suffered my whole life. In my family, they are hereditary. I am right now searching the Karen Reed. Um, I'm doing just seeing live streams. Mm. So, yes, I'm searching Karen Reed, y'all. If I am not the energy I'm normally at, that is why. Is because I definitely am struggling with this migraine. We've had a lot of changing in the pressure and the things that have been going on in our see I'm squinting a lot in our weather, and that can trigger migraines. I'm looking for court. What? Does Karen Reed give an interview? I'm looking, y'all. Oh, I'm looking, y'all. Everything I'm looking at is short. I want court feeds. Karen, that's fabulous, but do me a favor, put it in the mod chat. I did that before I came live. I did that before I came live. This is only a no. I'm looking for the actual. Um, I am actually looking for and mod if you can find it, great. I'm actually looking for some court. Just as good morning. Good morning. I am a little bit migrainey this morning, so please grace and mercies for me this morning. Um, I'm looking for court videos on the Karen Reed. Um, I've decided I've just it sounds like I got something. Yeah, it's getting better. I took some medication. Um, Uvalde is some of the best migraine medication I've ever had. And what's great about it is I can take it and I'm not groggy, I'm not sleepy, and I'm already feeling it clear. You can tell by the frown on my headache on my head. Okay, Karen Reed case motion hearing. I have pulled it up. It's about an hour long. Are y'all cool with watching that? I just think that I didn't want to do this, but I think because of all the rabbit trails that's happening with this, I think it good morning. Good morning. Because of what's happening with this particular trial, I think I'm going to have to do a little bit of it. Um, so that is kind of where I'm at. I'm going to take this off the screen because, um, Justice, do me a favor. Um, can you tell any difference between my video today and yesterday? Um, and by the way, guys, you may have a different name, and we know that in the mod chat. But for the public reason, I will call you by what y'all are marked on the screen. First of all, what was I going to say? That dang headache. The name that we have currently for this this particular channel is Alternate Juror. I did some research and I did some talking, and I think what I'm going to do for now is keep it. The reason is I can't now. Once again, if it becomes an issue, we'll change it. But for now, I'm going to keep it because I feel that nobody else out there is really using it like we are. And like I said, if it becomes an issue, we'll change it. I still have the names. I have a, that's what I forgot. Nabbit. I'll get it at a break. Okay. So we're going to play this, and please comment, like, and subscribe. Mods, please see if you can bring your friends in. Tell them you're on. Get them in here. Yo, let's get this channel blowing up. Let's blow up this channel. I want to reach 1,000. I know some people think, wow, but man, there's people out there with 30, 40, 100. I mean, some people have 500,000. I don't know if that will ever happen, but I sure do want to reach 1,000. I want to reach 1,000. I'd love to reach 1,000 by the end of the year. You're rocking. Okay, so let's get this court thing done. Let me get it into Skew. Let me do this. I'm going to share it. Get everything organized. Once again, if you're just hopping on, I'm Ada K. Brown. I am your alternate juror. And if you comment, like, and subscribe, I'd really appreciate it. I have only been doing this. This is into my 5th week, and it has been a wonderful journey. As of yesterday, officially, I have mods. So mods. Great job. Great job, mods. Great job. Lindsay, thank you. All right. So, with that, let's listen. Now, I heard this got a little spicy. Let's see. Wow. Their audio sucks. Okay, let's get past that. Woo, doggy, that was awful. Okay, is that better, y'all? How's the sound? Oh, God, that's good.
Thank you.
We're going to fast forward.
No, Your Honor, I would just state that the Commonwealth also does not object. Spoken to legal counsel from state police, they do not object. Whatever limited materials are available at this time have already been provided to counsel for both sides with the recognition of an ongoing obligation to provide materials as they exist. So no objection to that being allowed without objection.
All right, so that's one done. The second motion that I'd like to start with is the defendant's motion for Rule 17 directed to Kevin Albert, Brian Higgins, and Brian Albert. Before we begin on this, Mr. Lally, is the Commonwealth opposed to either of the other two motions? Just either yes or no. And
Alan,
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe so.
Okay. All right. So I'll hear from you then, Mr. Yannetti, on your Rule 17 motion. seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor,
Oh, it's had
Brian
some.
Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text.
Ah! My bad,
Have
y'all.
access to the material.
Lally is on this. Mr. Lally,
My bad,
is the
y'all. I'm
Commonwealth
sorry. I hit the wrong button.
opposed to either of the other two motions? Just a yes or no? And
Yes.
okay, and do we have third-party counsel here on either of these objecting?
Yes, I believe
I
so.
am
Okay.
still trying.
All
to
right, so
learn
I'll
how
hear from you then, Mr. Yannetti, on your Rule 17 motion,
wholeheartedly.
seeking records from April 23rd to the present.
Thank you, Your Honor. With regard to this motion, Your Honor, Brian Albert was served with a subpoena to testify before a federal grand jury, and he begins reaching out for Brian Higgins. Brian Higgins testified to the federal grand jury that he stopped taking Brian Albert's calls. He stopped replying to Brian Albert's text messages. It's fair to say that led to a panic in the Albert family. We learned that Brian Albert contacted his brother, Canton Police Officer Kevin Albert, to intervene.
I'm actually going to stop you there for 1 second. Mr. Lally, is
Whoa.
Kevin Albert a Commonwealth witness?
No, Your Honor.
Okay, I just wanted to clarify that.
Now, bear in mind, Your Honor, that the Canton police were supposedly conflicted. Okay, we're happy to provide that. Judge.
Okay, so I'd like it by
can-
tomorrow morning.
That's fine, Your Honor.
Mods, did y'all? Did it glitch out? Or
So
did y'all
the
kept
Canton
hearing-
police
hearing
had
it?
a conflict precisely because Kevin Albert is an officer in their department. So how can they conduct an investigation which includes the
That
brother
was
of
news
one
to
of
me.
their
I'm like,
officers?
huh?
It stands to
Out
reason
here.
they can't. They appeared to recognize that. Yet
Mm-hmm.
Chief Berkowitz is talking to witnesses in this case, and Kevin Albert himself inserted himself into this case. Brian Albert testified to the federal grand jury about the fact that after Brian Albert received a federal grand jury subpoena, Kevin Albert contacted Brian Higgins. Kevin Albert said to Higgins, and I quote, "Look, you went off the grid and Brian doesn't understand. You haven't called him, you haven't checked in on him since these subpoenas go out. Everyone got a subpoena but you." Those were Kevin Albert's words to Brian Higgins. And Your Honor, there's only one way to interpret that. Brian Albert was panicked that that Brian Higgins had flipped on him. Brian Albert enlists his Canton police officer brother to contact Higgins to try and find out if that was the case. And it wasn't just text messages between them. After first testifying that he didn't want to talk to Kevin Albert about the investigation, Brian Higgins later admitted that before he testified before the federal grand jury on June 1st of 2023, Higgins and Kevin Albert talked on the phone for a good 15 minutes. That was 2 days before he testified before the federal grand jury.
So I'm back on.
Before he testifies to the feds, Brian Higgins is conferring with Kevin Albert, who's supposedly conflicted out of the case. So, my goodness, with all the allegations of witness intimidation thrown around by this DA's office and special prosecutors they appoint, why has Kevin Albert never been investigated for witness intimidation? And for that matter, why has Brian Albert never been investigated? But as you ponder those questions, please realize, Your Honor, we're not asking for much here. We're only asking for relevant phone records. We're asking for contact between Kevin Albert and Higgins and Brian Albert. We're asking for contact that violates the recusal, the self-recusal of the Scranton Police Department from this investigation. Contact which impeaches them, contact which is relevant to their motives in this case. It impeaches the investigation. We are entitled to explore whether this investigation was conducted correctly and ethically. And we're entitled to explore whether improper influence was put upon witnesses by the Alberts. Without this testimony, this federal testimony from Higgins, and without the federal investigation, we never would have known of Kevin Albert's involvement here. But now we do. And the Commonwealth does. Why aren't they curious about what was said and why? They've announced an objection to this motion. Why are they fighting our quest to get exculpatory evidence? We need this evidence, these phone records, in admissible form. That's why we're filing this Rule 17 motion. We have more than met the requirements of Lampron. The records are relevant because they tend to show a cover-up. They are relevant because they show a Canton police officer inserting himself into a case in which his department was conflicted out precisely because he was an officer there. They're relevant because they impeach the credibility of Commonwealth witnesses who deny that they are a part of a conspiracy, yet the phone records tend to show they were conspiring together. We cannot get these records any other way. We cannot effectively prepare for trial without these witnesses.
So you testified as to their relevancy. How are they evidentiary?
They're evidentiary because they are both relevant and material, and if they're provided by the providers with an appropriate affidavit from a keeper of records, they're admissible. The Commonwealth could have gotten these records at any point, but they chose not to. And they have fought our efforts to get all phone records. Thank goodness another law enforcement agency stepped in and did the job that the DA's office should have done, but did not.
They have the right to
We need these records. Going to trial without them would violate my client's rights to exculpatory evidence. It would violate her due process rights. And finally, to the extent that this court previously ruled that our requests for phone records were a fishing expedition, nobody can claim that anymore with a straight face. We now have testimony that these records exist, that calls exist, that text messages exist. As Mr. Lally said in the last hearing, phones do not lie. These phone records do not lie. We need them, and we ask the court to order them.
All right, it looks like you're asking the parties themselves to bring these in, though.
To the extent that they have them, that's accurate, Your Honor. We're also asking for their phone providers to
So
provide them as well.
they're two separately filed motions, right? And
Yes.
one of them is with
What's your
Mr.
opinion on this?
Berkowitz, or former Chief Berkowitz,
Let's
but
go
he's not on the
tsunami.
other. So I saw them as two distinct motions, and one, the one that we just heard you on, is really asking them to deliver whatever records, right?
Correct. And I would note that the providers are on the second motion, except
But
for
that's three different people or one different person on this.
one different person. So we have Higgins and we have Brian Albert on the first motion. We have Higgins and we have Brian Albert on the second motion. The difference is Berkowitz versus Kevin Albert.
Right.
Right.
Wow.
Okay. All right. Mr. Lally, I'll hear from you, and then I do see Mr. Henning here. I don't know if he wants to speak or not, but I'm going to hear from Mr. Lally now.
But we'll see what happens. Because I have to have my hands up high.
Your Honor, just very briefly with regard to this motion. With regard to the Rule 17 motion with request to records or communications from individual cell phones from April 1st of
sound okay like
2023
this,
to the
guys?
present
Or no?
day. Firstly, the Commonwealth would just indicate the facts as recited in the defendant's motion the Commonwealth would submit are largely inaccurate. It's injected with hyperbole, injected with conjecture. In regard to federal grand jury materials, which belie much of what counsel claims that they say. essentially unsubstantiated conjecture, which is directly contradicted by the testimony and the evidence contained within the federal materials. Now, I know that the court has had those materials and has carefully reviewed those materials, so I don't feel the need to go into each and every specific ground. However, what I would say is, secondly, even assuming that everything contained within counsel's motion was true and accurate, the defendant's motion in this specific instance fails on two grounds. Number one, what the Commonwealth would submit is that the time period that's being requested is far too overbroad for whatever collusion or whatever purportedly occurred, according to counsel, going from almost a year worth of communications from people who, admittedly, through the testimony and through the evidence that was presented and has been presented in both forms, knew each other well and knew each other well before any of this occurred, and continue to associate and be friends following this incident. Secondly,
Okay.
the sort of last paragraph of counsel's motion claims that the records are needed to establish the exact nature and extent. What the Commonwealth would submit is really what they are needed for, from counsel's perspective, is to establish the existence of these conversations and what the content of them were, which is the very epitome of a fishing expedition. And so for those two reasons, the Commonwealth would submit that the defendant has not met the standard on the Lampron, and that motion should be denied.
All right, so I see Mr. Henning, so I don't know, do you want to be heard? Yeah, please come forward. And I don't know who counsel is for Mr. Higgins, but if he or she's, do you want to be heard as well, sir? Great, so I'll hear you after I hear from Mr. Henning.
Good afternoon, Your Honor.
Good afternoon.
On behalf of Brian
Come on,
Albert,
cameraman.
I just wanted to put three
Gee,
things on
yeah.
the record for the court. The
Court
first
TV, you
is,
should
and I'm
be
sure
better
the
than
court
this.
is aware, that the parties that are the subject of the Rule 17 motion have not actually received the motions. We got the cover page, we got the orders and the proposed orders, but we have not been able to review the actual memoranda because, at least according to the interpretation of the protective order, we're not entitled to see that content. And that,
All right. I ruled that they were to be given because the federal proceeding is not to interfere with this court's proceedings.
I understand that, Your Honor, and I did
All my
receive the court's
muddies
order,
are
and I
here.
informed each of the respective
Right,
counsel that I
so
spoke
I'm
to
back.
as far as what the court's order was. And I also understand that the court hasn't had the opportunity to review the federal protective order, but my interpretation of that order simply would not permit dissemination of the material contained within the memorandum.
Even though the Lampron Protocol says shall, doesn't that supersede a federal protective order? It's the law of the SJC. How can third-party record holders, the people who Rule 17 in the case law protects, not be able to go forward without it?
And I understand there's a direct contradiction there. And so, out of an abundance of caution.
Okay,
that's-
no, I understand you're following your order. I'm going to make it available. Not a party to any protective order.
Understood.
So we can take a recess. You can have them now. What do you all want to do? I mean, I didn't know that the Commonwealth was not complying with my order. I understand why you didn't, but I didn't know that.
My
Did
apologies.
not know they
Um,
were not.
I'm happy
complying
to
with
be
the order.
heard now, and if the court will allow us to review the motion and the memoranda, we
OMG,
can
y'all.
amend with a written filing if there's something that we need.
Yes, pursuant to a protective order, the way we have them in the Massachusetts courts for Lampron Dwyer records.
Oh my gosh, y'all.
So,
Can I have one moment, Your Honor?
yes.
Not complying with the order? I'm getting that picture. I am getting the picture. Oh my gosh.
Your Honor, what I think the counsel for the third parties would ask is that we are able to address the court today, but allow us an opportunity to review the memoranda and submit something in writing before the court makes an order.
Sure.
Wow.
I'm just rereading the appendix on Dwyer, and it is a shall. So my view is that the SJC in Commonwealth versus Dwyer, the procedure that we're to follow allows certainly, and I say mandates, that the third-party record holders be given this information. So we will provide it when we take a recess today. I'll ask Mr. Clerk to make copies of what I have, not what the lawyers have. We need protective orders signed before you're given them. And I will have them given to all three record holders, or four if there's somebody here from Mr. Berkowitz. All right, I'll hear you.
Thank you. The first part of what I wanted to address is dovetails with what Your Honor is just addressing. The fact that we are third parties in this matter and do not have access to the materials that are in the subject of the discussion
Are you
from
kidding
the
me?
federal side of things makes us at a disadvantage here in front of the court. Obviously, we're going to remedy that hopefully by being able to review it. But that notwithstanding, the fact that there is materials that we can't review that are being discussed in front of the court, even if we are able to see the memoranda, makes it difficult to address these. And I think for an issue of fairness, I want to make sure that the record's clear. If there are future motions, I want to preserve and not waive any argument as to the fairness of being able to access those records. So that would be the first point. The second point
Lady,
is,
how are
going
you,
into this not having an
beloved?
opportunity to review the record, I do believe that the Rule 17 standard of relevance still needs to be
Oh,
met
thank you
regardless
for
of whether we get to see the
saying
material or
that.
not. So what I
Loving
do want to
kisses.
offer to the court to consider
are
as part of your
awesome.
determination here is that after receiving
I
the notice
watched
from
some
the
of your
Commonwealth last
stuff,
week,
lady,
I
and
contacted the
I
U.S. Attorney's
subscribed.
Office and I spoke to
I
the lead
love your
prosecutor in the
channel.
case.
Okay.
What I want to have the
Hey,
court
Kat,
know
how
is
are
that I
you?
have
Good
permission
morning.
to notify the court that Brian Albert, his wife Nicole, his son Brian Jr., and Caitlin are not targets of the
understand.
federal investigation.
Thank you
And I've been
so
given
much.
permission to
Thanks for
disclose that in
joining,
open court.
subscribing,
Okay.
liking,
So I
and
think it's important for the
Oh.
court to know that as you go into the
Been in
motion
that
that you're
panel
considering
well.
and the arguments from the defense. The third thing I would like to just ask the court is, notwithstanding everything that's just been said and reserving the right to file that written document later on, Brian Albert does not object to turning over the materials that are being requested. I understand that the Commonwealth may be having objections as to the Commonwealth's case, but Brian Albert does not have anything to hide. He does not have anything that he needs to prevent the court from seeing this material. And if the court does deem, after reviewing the material and having access to the federal records, that these are somehow relevant or that these are somehow admissible, and the court deems that Rule 17 has been satisfied, Brian Albert will comply with the court order.
Thank you very much.
Thank you. On behalf of Kevin Albert, present is Peter Paschuko, and on behalf of Brian Higgins is William Connolly.
Great. Thank you.
How many lawyers are there in this court case? My gosh almighty. I am going to have to sit down and
All right, so
Do a
counsel, I
graph.
need you to spell your name for me, please.
Yes, Your Honor. The last name is Connolly, Connolly.
And what's your first name?
a Welsh lady. They
William.
have been
Thank you.
showing me a lot of.
All right, I will hear you on behalf of
and I'm so
Mr.
thankful
Higgins.
for it.
Thank you, Your Honor. Your Honor, as the court is aware, Brian Higgins' phone records and
You're welcome here
communications are at issue
anytime, my dear.
in these motions. Brian Higgins is a federal ATF agent. He is a witness in the Commonwealth's prosecution of this case. And he has cooperated fully in the Commonwealth's investigation. As this court knows, we've not had the benefit of
This
seeing the
makes it
factual support
spicy.
for these motions,
Sense.
but I want to provide some information that likely isn't contained within those materials submitted to the court, but of which I have a good faith basis to believe is information contained in the materials provided by the federal government to the parties in this case. I have represented Brian Higgins since April of 2023, the month when he received the federal grand jury subpoena. Like he has in this case, Brian has cooperated fully with the federal investigation. He has answered every question put to him in both investigations, and he will continue to do so because he has nothing to hide. Brian Higgins is not a target of the federal investigation. That has
I get
been
it.
confirmed by the United States Attorney's Office and confirmed to me that I
Smart.
could make that representation in court. The U.S. Attorney's Office has continuously confirmed throughout its investigation that Brian Higgins is not a target of their investigation. Brian Higgins has not participated in any kind of a cover-up or conspiracy to cover up the criminal activity of others. Brian has spent his career saving lives. He was a firefighter before becoming an ATF agent. He has been an EMT since 1992. He received a congressional medal for saving the life of a fellow ATF task force officer after being shot 5 times in Somerville, Massachusetts. He has served our military in Iraq. Participating in a cover-up is contrary to who he is as a human being and a professional. I am here to represent Brian's interest in privacy. Brian Higgins, at my urging, will not capitulate and stand down when efforts are made to further intrude upon his privacy based upon sheer speculation. It is for that reason that we oppose these motions, not because Brian Higgins has done something wrong or has anything to hide. We know this court will give us an opportunity to review the motions and supplement our remarks if we deem it necessary. We know this court will fairly weigh the arguments before it and will render a fair decision, and we will respect that decision and we will comply with that decision. Respectfully, we do not believe there is a sufficient factual basis to support the relief requested in the motions before the court. Thank you, Your Honor.
All right. Thank you very much.
So you're telling me, and remember, I've not been
Counsel?
following this case for a reason, but so what you're telling me is that they have not been given the phone records for.
Good afternoon, Your Honor.
The
Attorney
people
Peter Paschuko
involved?
on behalf of Kevin
All
Albert.
right, so you need to spell that last name
Sure,
for
it's
us.
P-A-S-C-I-U-C-C-O.
Good afternoon.
Thank you, Your Honor. Just a little bit of background with respect to Mr. Albert, and we are objecting to this Rule 17 motion. Kevin Albert's a 19-and-a-half-year veteran of the Canton Police Department, extremely well-respected, extremely well-liked. Any insinuation that he participated in a conspiracy or cover-up is simply untrue. There's been no showing how personal communications between my client and Mr. Higgins have any relevance here, let alone evidentiary value. Kevin Albert is not a Commonwealth witness. He did not testify in the federal grand jury, and his involvement is essentially zero. This is a clear intrusion, as Attorney Connolly indicated, into the privacy rights of these individuals.
Good morning.
And I've advised Kevin that there is simply no reason to acquiesce to something that's just clearly a fishing expedition.
Your request.
So upon my advice, Kevin Albert is objecting to this Rule 17 motion, but we will honor and respect the court's decision and appreciate the time to supplement any response in writing after we see the motion and affidavit, which hasn't been provided to us yet.
If you don't have a motion,
Thank you
and
very
affidavit, you
much.
don't have to comply to the
All
acquisition
right, Mr. Yannetti, did you want to respond or no?
request.
No, I would just move to the next motion if the court were ready.
Okay, so we'll move on to the next motion. Mr. Lally, you didn't want to add anything, did you?
Look at those lips.
Thank you, Your Honor.
Okay.
Kurt, pull back.
All right, so this motion concerns Brian Albert, Kenneth Berkowitz, Brian Higgins.
Yes, and Your Honor, with the court's permission, I'd like to start with Brian Higgins with regard to this motion.
All right, so Mr. Lally, is it safe to assume you did not provide or you didn't comply with my order and providing the motions and supporting affidavits on this as well to the third party record holders and their lawyers?
Yes, Your Honor.
Okay. So the council will receive copies of this as well and be permitted to argue now and supplement it. All right.
Thank you, Your Honor. As I previously mentioned, Brian Higgins did testify before the federal grand jury. And at that time, he was specifically asked if on January 29th of 2022, he made any phone calls when he got home. He said that he did not. He testified that he lived alone. He testified that he was alone that night. He testified there was nobody else in his bedroom. He testified that when he went to bed, he placed his phone on the bedside table. After making those admissions, he was confronted by a federal prosecutor with his phone records. Those records revealed that Brian Albert called Brian Higgins at 2:22 in the morning on January 29. Those records reveal, moreover, that 17 seconds later, Brian Higgins called Brian Albert back, and that call lasted for 22 seconds. Now, when he was first confronted, Brian Higgins first tried to claim that it had to have been a butt dial. That term butt dial is used by many of the Commonwealth's
How
witnesses
could it
to
be a
explain
butt dial if it's
the many calls
on
between them and among them. And I've never
the
seen a
side
case where there have
table?
been so many butt dials, to be frank. But Mr. Higgins was already
How many
locked in.
times is he going to say
He
butt
already
dial?
testified his phone was on the bedside table. His butt was in the bed, the phone was in the table. The two could not have met, Your Honor. There was no possibility of a butt dial. And then Higgins admitted that. And that wasn't Mr. Higgins leaving Brian Albert a voicemail. He also admitted under oath that the toll records
I guess
would
some
have
of y'all have seen
reflected a
this already. I
voicemail if they
apologize,
went
I have
to
not.
voicemail. He admitted that to call Brian Albert back, he would have had to first reach for his phone, then unlock it with the passcode or Face ID. Then he would have to press on Brian Albert's number. And that is exactly what he did. And he testified that that was what he did. He also testified that nobody from the Commonwealth, not Trooper Proctor, not ADA Lally, no one has ever asked him about that phone call from Brian Alberts to Higgins, or the return phone call from Higgins to Albert lasting 22 seconds. Rather than get everyone's phone records, as this court knows, the Commonwealth has fought the defense at every turn in our quest to get the phone records. They've persuaded this court that we were previously on a fishing expedition. To the extent the court once thought otherwise,
How is that
it
a
is clear this is no longer
fishing
a fishing expedition. We
expedition?
do not have to go fishing to wonder anymore whether calls were made. We now know that someone who had been in that house when John O'Keefe arrived called the homeowner at 2:22 in the morning, 3.5 hours before John O'Keefe's body was found on the homeowner's lawn. We learned that neither party to that call ever revealed to police, investigators, or prosecutors that they connected
What?
by phone in those early morning hours. Just like Jennifer McCabe never revealed that at around the same time she was Googling, asking how long it
Okay, since this is not live court, I want to stop and talk about this. Had to reseat my ears. Y'all, just FYI, if you can't tell by my face, the migraine's down to a low 3 out of 8. So the migraine's getting much, much better. So thank y'all so much. Are y'all, some of you guys have probably already seen all this, and I get it, but this is news to me. Are you telling me that, is it Brian? I gotta keep up with everybody. That someone is stating that they were asleep in bed and the phone was on the table next to them. And then when they were questioned about a phone call that was placed at 2:23 in the morning, is that what he said? He said it was a butt dial? I have a large butt, but dang, that butt's got to be big. I just want to go. Sorry. Why is it shorting out on me? That's what I want to do. What are you talking about? Oh my gosh, y'all. Are you kidding me? Are you? Oh. Oh. 13 jury, you are freaking amazing. Oh. Uh, 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 Okay. Yeah, baby. Oh my gosh. Y'all. I am saving the flow chart. I'm going to print the said flow chart just so I'm not going to publish it. I won't do anything like that without permission. But just so I can follow along with this, because y'all, this is juicy. And I almost did not cover this. Mods, you are awesome. Oh, much to learn I have, said Yoda. I will go and listen to her podcast, but I don't know. Wait, oh, mods, I don't know what to do. I don't know what to do, mods, because it's like, if I go and listen to everything before the trial, I won't have the alternate juror view. And I'm looking for that alternate juror view. I don't want to break the rules that I set up for myself. I'm listening to this this is a court hearing that was live. Okay. Oh my Lord, y'all have mercy. What's y'all's thought about this phone thing? There it is. What's your thought about this phone thing? You're s- you're sitting here telling me. I think I'm just going to use the charts for the follow through. I'm actually going to print them so I can see them. But um, oh, Miss Kevin, possibly so. Good morning. Oh my. Oh my. As my great grandmother used to go, my. Let's keep listening.
Took for someone to die in the cold, a search that the FBI confirms happened at 2:27 in the morning, again, about 3.5 hours before John O'Keefe's body was found. Now, for his part, Brian Albert also first tried to claim that his phone call to Brian Higgins at 2:22 in the morning was a butt dial. He said that he was awake and watching TV, but he was called back to the grand jury to testify a second time.
Hello.
The second time, Brian Albert changed his testimony to say that at 2:22 in the morning, he and his wife were in bed in an intimate situation. He claimed that he had his phone with him in the bed. So now he's claiming that it was during that.
Whoa. Back up. How many people have no, I may be just old school. I just may be non with the times. How many people have their phone in bed in the midst of an intimate moment unless you're doing something like recording it? Agree. Auntie Bev can make or break this case with what she can, but there's also though the appeals process if she goes where she's not supposed to. But oh my gosh, in bed with him? That's what he's saying? I would then say, and what were we doing with the I'm leaning way too far. And what were you doing in the bed with it?
Intimate situation with his wife that he supposedly butt dialed Brian Higgins.
Then
He had
Brian
no
Higgins would have heard the
explanation, however,
intimate
for how
moment.
his phone picked up when Higgins called him back 17 seconds later. He had no explanation for the 22-second phone conversation that followed. And it's worth noting that Higgins testified he never heard any intimate noises on the other end of the line either. Brian Albert tried to maintain that he butt.
Snap. Oh, snap. Okay. Guys, we can't say that P 4-letter word or type it. You can just say something along the lines of adult image. So we can't say that. I have to delete that comment. I'm sorry, Lego. But yes, you were right. Mods, that is one thing that we also need to watch for. Anything that has P in the beginning of it, 4-letter word, we need to not have on there. I know we're all learning. That's okay. No, that's okay. But you can do adult content. That's what we can write. Oh, right. All right. Watching naughtiness. That'll work. That works. Yep. That works. I'm corn like the band. Eddie, I will learn how to do that. My brain is not functioning yet to do that. I've had a migraine all morning. Uh, Ronnie. Karen, I'm trying to understand myself. That's why okay, so this is one of the guys that was in the house. That's one of the friends of the deceased. Am I right? Just some of the other mods can fill you in more than I can because I'm looking at this with fresh and clean eyes and I'm trying to follow along. But apparently, oh, Ronnie, I love it. Yes, exactly. Exactly. Okay, so I just need to know where to go in to do that. I don't know how to do it, but here's the thing. So you're telling me that you have one person in their house asleep. You have a person in the house where the body or deceased was found. And there was calls back and forth at 2:23ish in the morning. And they're both saying it was butt dialed. But yet one said it was on the nightstand when they were sleeping. The other one said they were being intimate with their wife, and they're both then saying they're butt dialing each other. That has to be one large errors. One large errors. One large. Oh, y'all. Y'all. Golly, y'all. OMG. I got to look at this real quick. We're going to push play now.
Dialed Higgins. But again, that would mean that his butt also answered the phone when Higgins called back, and it doesn't make any sense. Both men denied talking to each other despite being confronted with that mountain of evidence by federal prosecutors. But it wasn't just the January 29th, 2022 calls between Higgins and Albert. Brian Higgins' phone records, we learned, reveal that Canton Police Chief Kenneth Berkowitz was involved in interacting with both men shortly after John O'Keefe's body was found. And again, recall they're supposedly conflicted out of this case.
So I'm going to, there's just a question I have, and I'll let you continue, Mr. Yannetti, but regarding the dates. So the dates of the records you're seeking
January
for Brian
29th.
Albert, so January 29th to February 4th.
Or 4th or 5th, yes.
4th.
Fourth.
That's what you're
That's
seeking.
fine, that's fine.
And for Kenneth Berkowitz, January 29th to February 18th, and Brian Higgins, January 29th to February 18th. I need you to explain to me why those dates, why
Right, so-
February 4th and February 18th.
There was testimony in the federal grand jury that Berkowitz and Higgins were speaking to each other up through the 18th. With regard to Mr. Albert, we had evidence through the 5th.
All right, it's not entirely clear from the affidavit. Okay.
That's a
Right.
whole new.
So go ahead.
been
Thank you for
butt
answering that, and I'll hear you. Go ahead, continue.
Right. So as soon as John O'Keefe showed up deceased on Brian Albert's lawn, Canton Police decided it might not be a good idea for them to be involved in investigating this case. And by the way, I'm reminded when I sat down that District Attorney Morrissey announced that publicly. So we knew that early on.
Okay, so is that in his statement that I've had copies of?
It is not in the video statement that we moved to sanction him for. It was a previous statement that he issued.
All right, so get that to me, okay?
That's fine, Your Honor. So the question is, why was Chief Berkowitz inserting himself into this case almost immediately? United States Attorney Joshua Levy questioned Higgins about that in the federal grand jury. He summarized the phone records in their possession, records the feds have that we do not, records we're
Yes,
asking this
Mary.
court to order so that both parties in this case can review them. Mr. Levy directed a question to Mr. Higgins in the grand jury.
Good morning,
where
Mary.
he
Am I
asked
going to
about
see you
all of
this
the back
morning?
and forth
I'm
between
waiting
him
for you.
and Brian Albert and Chief Berkowitz. Quote, you have a 3-minute call
Y'all,
from
Mary is one of my
with
dear
Berkowitz
friends.
at 7:22 in the morning. This is on January 29th. Another call with him for, then you have a call with Brian Albert that afternoon for 12 minutes. Another call with him for 6 minutes. Another call for a minute. Then another call with Albert for 10 minutes. Then a call with Berkowitz for 4 minutes.
That's not a
Higgins
butt.
spoke with Berkowitz on January 29th, someone who was
Sorry.
conflicted out of the investigation 4 times. And then they spoke many additional times between January 29th and February 4.
But Higgins had nothing to do with the investigation, correct?
He was a witness in the investigation.
Okay, at that point,
We
at
have
that
a
point,
chief of police who's
so
supposedly,
I'm sorry, I just need to, so at that point, you say he was a witness?
I'm sorry?
At that point, the point of the phone calls, he was a witness?
Yes, he was in the home, Your Honor.
Okay.
He was not spoken to by
He was in the home at
investigators
the
yet,
time.
but clearly he's a witness. He was at the home that night.
Oh.
Now, recall that Chief Berkowitz supposedly found a piece of taillight on Brian Albert's lawn on February 4th, after that lawn had been searched by
What?
trained investigators and other police officers multiple times without finding it. But somehow Chief Berkowitz was able to spot that piece of taillight while he was driving past the property from his moving vehicle.
Morning, Mary.
And the phone records show that Berkowitz called Higgins that very day to tell him about the discovery, and then Higgins calls Brian Albert to tell him. In a case where we are alleging as part of our defense that there is a third-party culprit, and at least some people are involved in a conspiracy to cover up the guilt of that third-party culprit or culprits,
Wow.
contact between co-conspirators could not be more relevant. Before the feds got involved, we fought for this information, but we were largely unsuccessful. Although we never had to prove that the phone records actually contained evidence of the conspiracy. That's something we couldn't do without having the records themselves. This court has previously ruled that it was all too speculative. Not anymore. Not now. Not after we know that the records exist. Not after we know they prove what we suspected that they would prove. We now know that those records will tell a story that could not be more relevant to this case and to our defense. And the problem, Your Honor, is we know the records are there. We have them in summary fashion, but we don't have them in admissible form. The feds have revealed that they exist, but they haven't released the actual records to us. They have them, we don't have them. That's why we're filing this Rule 17 motion. And again, we've more than met the requirements of Lampron. These records are relevant to our defense because they show suspicious contact between parties we allege to be in a conspiracy. They're relevant because they show the Canton police chief inserting himself into a case when it was previously determined that he was conflicted out. They are relevant because they impeach the credibility of Commonwealth witnesses who denied talking to each other, yet have no explanation for these records, which again, do not lie. We cannot get the records any other way. We cannot effectively prepare for trial without these records. The Commonwealth could have gotten them, but they chose not to. They fought our efforts to get them. But again, thank God, another law enforcement agency stepped in and did what the DA should have done.
The feds have stepped
Going
in.
to trial without these records would violate my client's due process rights. And finally, to the extent that this court previously ruled that our requests were a fishing expedition, we can't maintain that now with a straight face. We now have the receipts. It's confirmed we were never on a fishing expedition. We were merely on an expedition to obtain relevant material and exculpatory evidence, and we're simply on a mission to defend our client. And I would ask the court to allow this motion.
All right, thank you very much. Mr. Lally?
So, Your Honor, the Commonwealth does not object to this motion. The only question or clarification that I'd ask for is there seems to be a
Cameraman, come
discrepancy
on.
in the dates that I'm not
Come on,
really
dude.
finding any support for within the context of the motion. So
So that's why I asked. So,
my question was a different one as to the dates, though. So when it directed towards individual people, it's a time period beginning on January 29th. When it's directed towards the cell phone carriers or providers, it begins with a period on January 28th, which is the day prior to
That's
anything
reasonable. You
occurring.
want it the
So
day
I'm not
before,
sure
so
why
you
anything
touch
on the
everything.
28th has any relevancy. There's nothing in the motion that I can glean that indicates that. I don't know if it's a Scrivener's error or if there's some other reason for that period for those providers to be starting a day early.
what do you say about that, Mr. Yannetti? Your affidavit says the 29th.
Right. I would orally amend that to the 29th, Your Honor. We're fine with that.
All right. I'm going to hear from the third
Well, thank you
party
so much for joining.
counsel if they
Yeah,
want to be heard.
This is your
Your Honor, if I
open
may, just
request.
one further thing. I
Please
did speak
comment,
with
like, and
counsel, it's
subscribe.
Attorney Kenneth
Sure.
Anderson, who represents Mr. Berkowitz. There's no objection on behalf of his client.
Okay, thank you.
My doggy had an
All
itch.
right, so Mr. Conley?
Yes, thank you, Your Honor. Your Honor, well, with respect to our general arguments, we'll just rest on I'll rest on what I said previously.
Come
with
on,
respect to
cameraman,
parties'
really?
positions.
Get a grip.
I just want to point out one thing with respect to the
Actually, I haven't
factual
even seen
assertion.
how to use it.
I don't have the privilege of seeing the grand jury testimony. But I can represent to the court that before my client ever testified at the grand jury, he voluntarily appeared for an interview with the U.S. Attorney's Office. I attended that interview, and at that interview, he volunteered to the U.S. Attorney's Office that that morning he spoke to both Albert and Berkowitz. He was not asked and did not give a rundown of how many times, but he acknowledged long before he testified at the grand jury that he did speak with both of them that day. I don't think that impacts the substance of the
So you
arguments, but I
can't
just
hear
wanted
me?
to note that for the record.
Okay, so just so I'm clear, the Commonwealth hasn't objected to these records for that period
Yeah,
of
Mary, you
time.
run it
that
better than
appears
you
to be
can.
relevant
Yeah,
time period.
this
and
better,
so I
guys?
will waive argument on that, Your Honor.
All right, and does counsel object to these records?
I
Mr.
believe
Henning on
my
behalf of
microphone.
Brian
Is
Albert?
that okay?
All right, and
I
counsel
got to
on
keep
behalf
it out of the
of-
red zone. So we
Okay.
don't have to.
Oh, that doesn't concern you. Okay.
Is that better?
All right. Thank you. Defendant filed, Mr. Yannetti, you filed a
way,
motion
Mary
that
doesn't
I
know how to
just
run
got
these
as I was
cameras.
walking out here.
Right, we're not asking to be heard on that motion. I had alerted your clerk that it would be coming. It's
So I
filed
can
with
talk
a
louder
motion
and
to
that's okay?
impound
Is
as
this
well. I
good?
figured I would hand deliver
I'm
it
just
today.
afraid of
Okay,
blowing
great.
my
Commonwealth
ears
just
out.
got
I
it
can't
today,
hear
so they'll need
myself.
time to assess that.
All right, so today, all pre-trial, non-evidentiary motions have to be filed pursuant to
Yes.
the
Is
order.
that
Yes.
All right, so
my
this is it.
Mary
This is what-
No, dear, I
Oh,
expect by the end of the business today, the court will be receiving a motion to dismiss to be heard next week as well.
All right, and you can't be here next week.
I cannot, and on that point, Your Honor, I think the court probably was alerted that we filed a second motion to admit counsel from California.
why is it
Pro Hoc
hard to hear
Vice.
me? I am
I don't know
gained
that
as
it's necessary.
as loud as
I'm glad you filed it because I think it is. If you're not here and you have to
Well,
be here
that's
for
why we
that,
did-
so
That's why we did that, so.
Ms. Yannetti will, I'll allow that motion now that you have filed your appearance.
Thank you so much.
Okay. All right, so you expect that there will be more motions coming today?
I expect there'll be one additional motion coming today.
All right. Does the Commonwealth have anything that it expects to be filing by the end of today?
Your Honor, just filed a motion for reciprocal discovery. I'm not asking for any action
Is-
on it, but I believe that would
Is
be it.
this better, y'all?
Okay, and I have one question. Are we all
I
done
changed.
with Bodie
my
Labs? Have you received the information from them?
So on one part of the testing, yes.
Okay.
On the second piece of the testing, no.
All right, so I need a report on that orally on Tuesday,
Sure.
where we are with that. All right, great. I'll see everyone Tuesday. Thank you.
Your Honor.
Thank you, Your Honor.
March 26, 9 a.m., hearing on all pretrial non-evidentiary motions.
All right.
Okay, we're done with that, y'all.
All right, Brian, we have a 3:00 list.
Okay, y'all. Y'all. Okay, well, some videos, the way they're gained, and that's why I need that switcher thing. But it's like $1,200, so we working on that. It's going to take me a little time. I'm not going into debt for this, but I will tell you, the investment in this is not little. And when Recovery Addict says I have a setup like his, I literally do. The only difference, he has that big switcher. And he has two more. Well, I have one computer, but it's a big computer. It's like huge computer running this. So, yeah, y'all, snap it. Okay. I'm going to move the video over here. I want to try and look at these. He has 4 computers, he told me. He may have 8 by now. Why is it everything opening up in the Canvas. I'm going to. I'm going to open it in Photoshop. But what I want to do is I desperately need to create some kind of mind game to be able to keep up with um these characters. Okay guys. I'm going to try and find another video and then I'm going to have to get a 5-minute break. The mods, when I go on break, it would be nice if you guys would just kind of chat amongst yourselves and kind of, here's the week one. I don't know. I can't do that one. There's a recap. Oh, I don't want to do that because I don't know if I can do that. Hi, Sparkles. Oh my God. 8 inputs for the switcher. Yes. And I am looking into that switcher, but y'all, it's great, but it's expensive. And I'm okay with getting it, but something's going on with the Alec Baldwin case. I don't know what it is. Karen Reed trial. So that was. I'm looking. Do you know if the jury selection was, that's not live, is it? I don't think the jury selection would be live. Okay. Oh, this is a big talk on Court TV Live. I think I can play that. I think Ari has a media. He does. He has a degree. He does. He has a degree. And so oh my gosh, y'all, we're playing this.
Headlines. Her lawyers alleging in court documents that a fellow police officer was involved in O'Keefe's death and colluded with other people in a cover-up. You're alleging that law enforcement officials in the state committed murder and that they're covering it up. Why would they want to be involved in this?
Because he's dead. I think things went too far. It was late. There was alcohol involved, but they're all family. And there's many of them
Her attorney
involved.
let her.
After posting bail, Reed has spent much of the past 18 months in and out of court awaiting a trial date.
And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Prosecutors allege that Reed hit O'Keefe with her car
Yeah, I
after
knew that
getting
wouldn't
into
be
an
live.
argument earlier in the day, leaving him to die in the middle of a snowstorm in January 2022. But Reed says she had no reason to harm her boyfriend.
I would call him the patron saint of Canton. He was just very selfless, frugal, and I think you'd be hard pressed to find anyone that didn't care for John.
The couple first dated in their 20s and reconnected more than a decade later in the middle of the pandemic. So how did you
Wow.
meet up again?
He had reached out to me on Facebook and he said, "Hey, blast from the past, how's things?" And when I saw his picture, his profile picture was with several young children. And then it triggered my memory that his sister and his sister's husband had passed away. And he told me, yeah, I have the kids now. I admire
What?
that. I thought that was amazing.
Soon, Reed says she became part of the family, often sleeping over at O'Keefe's house and helping take care of.
Okay, well, back up. I know most of y'all got this, and I know most of you know this. By the way, I'm snacking because I took migraine meds. And if I don't snack, I'll get a little nauseated, and y'all don't need me in that boat. So you're telling me that his sister and brother died? Did they die together separately? And then he adopted the children? Oh my God, what an amazing man. And now he's dead? Oh, the poor children. Oh my gosh. Who is the children now? Who has the niece? OMG. I'm adopted, by the way, y'all. My twin brother and I were adopted.
Of the kids.
Oh,
He would go to work and I would stay with his niece and nephew. All of the breaks that the kids had, we did something.
But their relationship also had its struggles.
oh,
Reeve says O'Keefe had been relying more on her to take care of the kids and that he criticized some of the decisions she made with them.
We had had an argument on New Year's Eve. We were away on vacation and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve. And he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
A few weeks later, they were invited to meet up with some friends at the Waterfall Bar in Canton. And there, they ran into Brian
that's
Albert,
horrible,
a
y'all.
fellow Boston police officer who Reed says O'Keefe looked up to. Albert had led the city's gang unit before commanding the Fugitive Apprehension Team. It was the elite squad responsible for taking down some of the city's most dangerous criminals and featured in the 2013 TNT show, Boston's Finest.
Y'all. I hope I don't get a copyright mark on this, but we'll keep playing. Oh,
1 minute we're walking around,
OMG.
everything's fine, and then 1 minute it's not fine.
Both times I met Brian Albert, he seemed like the type of person that you'd be surprised he's out socially because he doesn't seem like he ever wants to be there.
But at the bar, Reed says there was an invitation to continue hanging out at Albert's home.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Alberts' house. What happens next is disputed.
So I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before she
Maude,
says
look at
she
the
fell
chat,
asleep around
please.
1:30 in the morning. She then says she woke up before 5 a.m. He still wasn't home. She then started canvassing the neighborhood.
Just going to drive around in the 2 square miles that we spent the preceding night.
After 20 minutes of unsuccessful searching, she called John's friend, Carrie Roberts, and Jennifer McCabe, Brian Albert's sister-in-law, who was also at his house the night before.
What? So how many people? Okay, thank you so much, Maude. How many people were at this house? Does anybody know? I need to pull. Okay, y'all need to educate me because, like I said, I purposely left myself out of this until we were going to cover it. So, were there 3, 4 people at the house? Was there 3 men, 1 female? Who was all at the? How many were at the house?
The 3 women together now headed to Albert's home.
3.
How soon was it when you pulled in there that you saw John's body?
Immediately. And what struck me when I saw him was his mouth was open a little bit and his eyes were shut and he had spots of blood in different areas on his face.
O'Keefe was taken to the
Wow.
hospital and pronounced dead. He died from blunt force trauma and
Okay, let's get.
hypothermia. And it wasn't long.
What? Okay, blunt force trauma, and then I guess hypothermia. But I guess it depends on where he was outside the house. Like, again, I know nothing. I'm learning. I'm learning everything here. I'm sure my questions will be answered, but I want to make sure I give some time for reflection.
long before Reed became the #1 suspect. Authorities say they had noticed a cracked taillight after they seized her car.
I had told both Jen and Carrie that I cracked my taillight. I said I just hit my car on top of everything, but I didn't look at the damage. And both women said, it's cracked. It's cracked. Calm down. You cracked your taillight. You're okay. Let's go look for John.
But according to police statements, Jennifer McCabe told authorities that while they were looking for O'Keefe, Reed stated, "Could I have hit him? Did I hit him?" And when O'Keefe's body was
She
discovered,
said, "What?"
first responders who arrived on the scene say they overheard Reed make other statements.
Firefighter said that you said, I hit him, I hit him, I hit him.
I said I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened was that did I incapacitate him unwittingly somehow, and then in his drunkenness passed out?
When you walked out of the bar, how many drinks had you had?
I had had probably about 4.
The Commonwealth
Let's have
says that you
some
had
more.
9 drinks that night. That's what the prosecution.
Okay, y'all. Where do you stand on this? I cannot. Like again, I'm sorry I'm snacking, but I have to, or I'm going to get nauseated. Not shattered, cracked when she backed out of the garage and hit his car. There's a video of it. Okay, thank you. Okay. But then if she hits him again with that same part of her car, then it's going to break because it's already compromised. But what I don't. So she's saying 4 drinks, and then I see in the caption it says Commonwealth said you had 9 drinks that night. Why was she even behind the drill out behind the car? I mean, the wheel driving if she'd been intoxicated. That in and of itself is a crime, and you're admitting to it. But what the heck are you doing giving this interview? Where is her attorney? Lawyer, where are you? Oh, Ronnie, thank you. We have Brian Albert, Nicole Albert. Are they siblings or spouses? Jennifer McCabe, Matthew McCabe. I guess these are all spouses. Brian Higgins, Brian Albert. Oh my gosh. Oh, okay. Wait, you got Brian Albert twice. Carlin Albert, Julie Nagel, Sarah, Colin. Oh. Yo. This is not cool. I am okay. Let's go on.
Prosecution says.
I don't believe they're saying I wasn't in my right mind.
Well, they were saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly
You
very
say yes,
large
I'm going to
SUV?
scream.
No, not possible.
3 days after O'Keefe was found dead,
Oh.
investigators arrested Reed for manslaughter. She was eventually indicted on second-degree murder. Investigators reported they found fragments of broken glass on the rear bumper on Reed's vehicle, and that a broken cocktail glass was found by what appeared to be patches of
I'll put
blood
it back up there
near
for a minute.
O'Keefe's body.
The victim, Mr.
O'Keefe.
O'Keefe, is last observed on surveillance video with a
Mr. O'Keefe
cocktail
was
glass in
deceased.
his
That I
right
know.
hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the
Mods
defendant's
go in
car.
the chat.
In
You
court
can download
documents, the prosecution also
the
claims
flow
that
chart.
Reed's blood alcohol level could have been between
might need it.
0.13 and 0.29%, above the legal limit of 0.08. In addition, they say pieces of Reed.
Okay, guys, let's talk about that. I don't drink alcohol. If I have alcohol, I fall asleep. I can't get drunk because I fall asleep. I kid you not. I fall asleep. Literally. So I can drink this much wine and I'm very sleepy. If I drink any more, I fall asleep. And then, but that level, how drunk is she? She's at a 0.13 to what was it? Something 9? 0.13 to 0.29. That's almost double or triple the legal limit. How intoxicated is that? Brian and Nicole own the home. Okay. All right, let's go.
Its tail light were found on the scene the day O'Keefe's body was discovered. More fragments of that tail light were found the following week, according to Canton police reports, after the snow melted, which revealed more at the scene.
How plausible is that, y'all? Okay, y'all, how plausible is that? I can see that being plausible. I don't know. I lived in Manassas, Virginia when I was like 4 years old, 5, 6, somewhere in there. So I don't know, but is it plausible, or would taillight fractions and pieces of taillight are not heavy? So if they searched that night, I would assume it would have been on top of the surface, or they would have seen little dips in the snow where something could have hit. Oh, snap. That's interesting. Where they were found were very not close to the road. Okay.
But Reed's attorney, Alan Jackson, has a different theory about how those fragments of taillight got there.
So the attorney's on the show?
Pieces of taillight were placed there after the fact.
You're saying evidence was planted.
All of this is before they go
Pieces
to
of taillight were
trial?
planted after the fact.
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical, and he was beaten. He was beaten to a point of unconsciousness.
Jackson argues that the autopsy photos of O'Keefe support his theory and not the prosecution's claim.
Looks like he's been in a fist fight and he's been beaten. He's got some defensive wound bruises on the backs of his hand. He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house. His body was placed outside.
But in a statement to ABC News, the prosecution says there was no conspiracy or cover-up.
Okay, mods, I need you to hang with this for a minute. I have to excuse myself for a quick minute. I will put some soft music on and I shall return. Can y'all carry down the conversation for a moment, please? Yeah, this I'm hooked. I shall be right back. Thank you for your understanding. Thank you so much, mods. You are so awesome. I am back. What did I miss? What did I? Oh, I'm all wound up. Oh, there we go. Okay, let me turn off music. All right, guys. So let's play some more.
Such claims have been systematically refuted by evidence submitted to Norfolk Superior Court. The prosecution also said that, according to O'Keefe's cell phone GPS records and 11 witness statements, O'Keefe never entered Albert's home, and that a medical examiner found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds.
ABC News reached out to attorneys for Brian Albert and Jennifer McCabe, but did not hear back by the time of this broadcast. In a previous statement to the Boston Herald, McCabe's attorney said the whole scenario is baseless. Reed is scheduled to appear next in court again in September.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News.
Okay, y'all. Interesting. Interesting. So let me catch up on the comments. I'm going to move this over here so I can see it better now. New comments. Thought the same thing. They only found 3 drops of blood. Yes, an internet hug. I love you guys. Love you guys. Thank you for covering. No body when the snowplow driver went by. Y'all, this is freaking amazing. I did not know this was going to get this spicy. Yeah, blood was collected in a solo cup. That's a no-no. Oh, that's okay, Ronnie. It happens. Just hop on when you can. So, first of all, that's, if I understand this correctly, we have a cracked headlight that she states happened at her garage, but the state or the Commonwealth, I got to get used to saying Commonwealth. The Commonwealth is saying that it happened when she hit him. And then you're telling me this hour. I'm trying to go back and find more video. Then you're telling me that a snow driver went by during the time that this supposedly the body was laying there and never saw the body. And then you're telling me they found pieces of headlight later after the snow melted? Are there any videos of her driving the car prior and after? Prior and after? Is there any? Y'all help me out here. Is there any video that they have as testimony? I'm perplexed. And why on God's green earth would her attorney allow her to go on an interview after all this when she's been charged? Those clips are missing? How in the hell did they go missing? I can see why a lot of people say this is a conspiracy theory, but I mean, y'all. I just can't. And I keep going back to the fact that he adopted his sister's kids. And now those sisters, those kids are with whom? They've lost their mother and father. Then they were adopted by their uncle. And then they've lost. Boy, you want to talk about abandonment issues as they grow up? I'm going to switch this back over here so I can read it and talk to you at the same time. How about that? No, that's not what I need. My computer is a very kick butt awesome new computer, but sometimes it's a little faster than I am. Justice, I can't believe this. Yeah, let's talk about the collection. Evidence is not collected in a solo. Well, let me take that back. I have been on scenes where they've collected things in Ziploc bags and styrofoam cups, but they were clean and sanitized. Clean. I mean, sometimes when you're in a situation where you have to get it before it's gone, I get it. But they're in a city. They have at their disposal within a moment's notice, they have a team of people that come here and they're called forensic investigators. I don't understand. Why would they have a need to collect it in a red Solo cup? They have a forensic team within minutes. Oh, somebody private messaged me, wanted me to show you my nails. So I'm going to show you my nails. Let me see if it will get it. May have to do this. There it goes. There are my nails. It's a girl thing, guys. The neighbors have a camera, but told the police there was no evidentiary value, so they didn't collect it. Are you kidding me? No, you get a subpoena and you freaking go collect every camera that was even on the path. By the way, y'all, I never really wear color like this. I never do them like this because when I interpret, we have to have our hands with just clear polish, and they don't even like you to have long nails if you're a professional interpreter. But I'm all like, I'm deaf now, and I have never seen a deaf group of people whose sign only have clear nails. They have all different kinds of color. Yeah, they're loud. They're loud. They're very bright. I thought it's close to summertime. Why not have a fun color? And I'm not professionally interpreting right now. So that's all good. I am going to be so blown by this case. All right, guys. Just because I can. What do you guys think? Guilty or not? It's hard to learn from something wearing polish for visually impaired kiddos. You're right. When I am professionally interpreting, I do not have bright colors on my fingernails. I could do something simple like this ish. But when I am professionally interpreting, I have clear polish. Like I said, I normally do not have a lot of color, but oh, well, I remember back that if you were in food service, you could not have fake nails, nor could you have a colored polish. I've talked to a lot of deaf people in my community. Maybe if I turn a little, it'll be better. And they tell me that it's okay if I have colored nails, if I'm close. It's okay. But when I start signing a lot here, I'll be in black clothes. It's easier for them to see because of the contrast. Oh my gosh, y'all. So guilty or innocent? Yes. See, it's easier the closer I am than if I'm further back. Because when I'm further back on a finger spell versus right there, you think she's innocent, not guilty. Okay. Well, we'll see when everything hits. I don't have an opinion one way or the other right now. But I believe there's a muckery about. I believe something is being covered up just from what I've seen. What? Oh, something else. Wow. So Monday, opening statements, I should say, is on Monday. Opening statements, and they're saying that this case can go 8 to 9 weeks. 8 to 9 weeks, y'all. I will be on every day that I can be on. But, oh, and that's the other thing. Monday, Wednesday, all day. Tuesday, Thursday, half day, I think in the afternoon. Friday, they're off. So we're really only getting 3 full days of court. Yep. Okay. You guys, I love you guys. I think I'm going to go ahead and call it because I'm not feeling very well. My stomach is not happy. I hope you are okay with that. But what we'll do is if anything happens, I'll hop back on. I may come on this afternoon and do Jail Widow. If I'm feeling better, I'll come back on this afternoon and Jail Widow. I will notify y'all in the chats, in the mods chat. If you would like to be a mod there, you can. It's basically the same thing. But we don't have court. We don't have anything to watch. I've had a long 3 weeks, 4 or 5 weeks with this other case. So I'm going to hop off. Y'all be blessed. Thank you again, mods. Keep an eye on your post. I will be hopping on and visiting with you shortly in that. Okay. All right, y'all. Be blessed. Have a great day. I'm going to pop that on.